Great. Right, we're ready to go. Cristina, over to you.
Thank you. Well, good morning, everybody. I thank you so much for attending. It's nice to be able to do events again, even though they are online, but hopefully we'll be back to normal soon. Right, a couple of just housekeeping things. If you have a question, please use the Q&A button at the bottom of the screen. If your question isn't answered, please don't despair, because one of our panelists after this event will contact you directly, so you'll be able to get your question answered there. Also, the session is being recorded, so if you'd like a copy of the recording, we can send that to you. All you need to do is just pop me an email and we'll send you the link. That's all on the housekeeping. So, as you all know, we've got 3 speakers or panelists, all from Freeths, who are going to spend 5 minutes just telling you about themselves and what they're covering. And then after they've introduced themselves, we'll open the floor up for questions, or you may have already sent a question in. So I'd like to introduce Emma Brooksbank, who is Partner Business Immigration. So she'll be covering all your questions that you might have on that subject. Dan McNally will be answering any questions on health and safety issues or food safety issues that you may have. And then we've got Emma Batten, who's the Managing Associate for Employment. So all of those questions that you have will be addressed by these people. So I'd like to hand over to the first panelist, who's going to spend a bit of time telling you about herself, is Emma Brooksbank.
Brilliant.
Over to you, Emma.
Thank you so much. Well, you're welcome everyone, and thank you for attending this webinar. We're looking at the evolving workplace in the food sector, and today really will be a broad discussion around workforce needs, workforce challenges in this sector, in the food and agriculture sector now and in the sort of short to mid-term future. So I'm just going to start us off with some thoughts around the immigration system and the impact that this has and will have on the availability of what we need in this sector, which is an on-demand and appropriately skilled workforce. So of course, in recent months, COVID has taken over the front pages, but despite that, we all know deep down that Brexit is still happening, and the transition period has just been ticking along. We're really close now to the end of transition, so we only have 5 months left. Transition will end on the 31st of December this year, and with that we'll see the end of free movement from Europe. Now we will also see the introduction of a new immigration system, so that's being called the 2021 immigration system. It will come in on day 1 of 2021, so on the 1st of January, and I'm yet to be convinced really that new immigration system is adequate or fit for purpose for this sector and for other sectors that have very specific workforce needs. Now, within the food and agriculture sector, it is fair to say that we do actually have one of the only sector-based schemes, so an immigration scheme that is specifically designed to meet the needs of the sector. That's in pilot mode at the moment, so it's the seasonal worker scheme or seasonal agriculture worker scheme, and it's been running as a pilot for quite some time now, and that pilot is due to be reviewed and come to an end in December as the new immigration system comes in. Now, it provided initially for 2,500 visas. That was then extended to 10,000 visas a year. These are really short term, so 6 months only, so it provides for 6 months in any 12 months, and they're really designed to meet the needs of the edible horticulture sector, so specifically the increase in demand that we have around harvest and all the related roles in relation to harvest, so picking and packing and production on site. But my question really around this is, is that adequate? So 10,000, we'll probably see an increase to 20,000. We probably won't see an increase any further than that. NFU, National Farmers Union, they say that there's 80,000 roles in this specific part of the food and agriculture sector. And the ONS tells us that up to date, 99% of those are filled by people coming from Europe. So as free movement ends, this is going to have a significant and immediate impact on the availability of that workforce. So really my first question, and I'm sure we'll start to see questions coming through, and my first point for discussion is, does that system, even if the pilot is doubled, is that going to provide adequate resource realistically to meet the needs of the workforce going forward? My second point for discussion, the second thing really that keeps me awake at night is, is adequate, is the food and agriculture sector, is it simply about harvest season? Does the scheme that looks to meet the needs of the edible horticulture sector actually meet the needs of the sector as a whole? And I'd say that, in fact, the sector will be a growing sector. In the current climate, particularly, we were growing anyway, pardon the pun, but in the current climate, you were looking at food security and actually having food sourced from home, from the UK, will become more and more important and more relevant. So we need a workforce that can meet that demand, and that workforce inevitably will be low-skilled, mid-skilled, high-skilled, and it needs to be available for more than just a short period in each year. It needs to be available in the long term in order to be able to build businesses within this sector. And of course, some of that workforce will come from the UK, but is it realistic to anticipate that it will all come from the UK? I don't think so. I think we need an immigration system that can meet that demand on a long-term, permanent basis. So I hope that's sort of given you a little bit of food for thought, as it were. I'm going to now hand over to my colleague Daniel McNally, who's really going to get into some of those highly relevant, pertinent issues that the sector's been facing over the last weeks and months, and he's going to look at health and safety issues as they arise for businesses in this sector. So over to you, Dan. Thank you.
Thank you, Emma, and good morning, everybody. My name is Dan McNally. I'm a health and safety and regulatory lawyer here at Freeths. When we talk about the evolving workplace in the sector, the one thing that's obviously prompted more changes than any in recent months, certainly from a health and safety perspective, is the COVID-19 pandemic. And whilst there hasn't been any change in health and safety law, which is well established, what has of course changed dramatically is how organisations in the sector are operating to safeguard their workforce. And as we all know, that's been prompted largely by lots of government guidance, and specifically 14 workplace publications, which were all intended to help employers make their workplace COVID secure. Now, the sector, like many others, has seen a number of well-publicised outbreaks of COVID-19 in the workplace in recent weeks. The obvious examples being in Worcestershire, Herefordshire, and looking back a little further, there was of course the incident at Cranswick Foods in May, when 3 workers lost their lives and a number of others had contracted the virus. Now this begs the obvious question, what lessons can we take from these incidents, and what are some of the key issues which the sector needs to be mindful of going forward? Well, first and foremost, we need to put things into context and be realistic about what we are dealing with here. Just because there have been outbreaks in the sector does not necessarily mean that those companies have not followed government guidance. It doesn't necessarily mean that those companies are in breach of health and safety legislation. The reality is that we are dealing with a virus that is prevalent in the community and be eliminated from the workplace categorically. That's accepted by the government and the regulators. The goal is, of course, to reduce the risk of transmission as much as is reasonably practicable. So context is something that we certainly need to bear in mind first and foremost. Secondly, of course, all businesses in the sector need to follow the government guidance, but in particular, they need to carry out a COVID-19 risk assessment, which sits at the heart of any effective health and safety procedures. If you are the subject of an inspection by the regulator, the first thing that they will ask to see, undoubtedly, your COVID-19 risk assessment. So you need to make sure that that is readily available. You need to make sure that it's up to date, of course. And I would also encourage those who haven't seen this already to have a look at the Health and Safety Executive's website, who not too long ago now published a helpful risk assessment template that you may wish to consider when reviewing your own risk assessments. Thirdly, once you've carried out your risk assessment and decided on what measures you're going to introduce, it's equally important that you monitor compliance with those procedures and monitor how effective they are. Now, the government guidance says very little about that, but it is equally important. And I know for a fact that inspectors are asking for evidence of monitoring and effectiveness, and they want employers to tell them about that, what they're doing, and they want to see evidence of it. So again, that's something that you need to bear in mind, as well as carrying out the risk assessment itself. Fourthly, of course, all businesses need to keep checking the government guidance, which is and has continued to change throughout the course of this pandemic. And whilst I don't think the goalposts have moved hugely, there is a risk that they may do in the future. And I think the risk to businesses is that if they are basing their procedures on old guidance, then if they are inspected, then they may well be found wanting and open to criticism from the regulators. And finally, and this is particularly important in the midst of what we've seen recently, companies, of course, need to keep accurate records of who is working on what particular day, as well as records of other visitors who attend the workplace for the purposes of track and trace. And again, that is something which is referred to in the government guidance. It is going to be absolutely crucial in suppressing this virus going forward, and it's something which recent outbreaks have certainly drawn attention to. So in terms of key lessons and what we need to be mindful of going forward, that is my view. I'd be interested to see what views you have and what experiences you have. But that's all I have to say for now. So I'll hand you over to Emma, who's going to talk to you about issues relating to employment law.
Thanks, Dan. Hi, my name is Emma Batten. I am an employment solicitor with Freeths, and you may recognise me from some of the HR forum updates that we've done in recent years. So what I was going to talk about today, very briefly, was just to give a bit of an overview in terms of the recent changes that have happened in respect of the government's coronavirus job retention scheme. So I'm sure anybody that is here that works in HR is fed up of hearing about furlough, and if your business has been using it, I imagine you are very well versed on the intricacies of it. But now that we're seeing a kind of winding down of the scheme, with there being a requirement for businesses to contribute to furloughed employees' wages, a lot of companies are now thinking about requirements, headcount requirements and cost-cutting measures. So as you may be aware, from the 1st of July, only employees that had completed a full 3 weeks on furlough leave between the beginning of March and the end of June could be placed on furlough leave. So it's no longer open to new applicants unless they are individuals who are returning from maternity leave or a period of adoption leave, something like that. The scheme is in place to run until the end of October, and at that point it's been made that it's clear that it will close. So from the 1st of July, a concept of flexible furloughing was introduced. So what does this mean? Well, essentially from the 1st of July, there's no minimum period of furlough required. Previously, it had to be in blocks of 3 weeks, and that has now gone. So what that means is employers can bring furloughed employees back to work any amount of time on any work pattern, while still being able to claim under the job retention scheme for any hours that the individual doesn't work. So this means, for example, that a business can bring an employee back on a part-time basis and furlough them for the period of time when they're unable to offer them any work. And for that period of time, the employee would be paid their normal, the normal salary for the period that they've worked. So in addition to the flexible furlough scheme being introduced, there's also been some changes to the amount of contributions that are expected from the employer, and that is kind of changing on a monthly basis up to October when it's due to end. So from the 1st of August, businesses will be expected to contribute national minimum wage, national insurance contributions and auto-enrolment pension contributions. And the government will continue to pay the 80% furlough pay. That changes from September, where as well as the national insurance contributions and auto-enrolment pension contributions, businesses will then be expected to contribute 10% of the employee's pay, with the government covering the cost of the remaining 70%. And then from October, that will increase to 20%. So the business will be expected to cover 20% of the pay, as well as the national insurance contributions and pension contributions, with the government footing the bill for the remaining 60% of the employee's wages. So in addition to because of these additional contributions that are occurring, like I say, I think a lot of businesses are now looking at commencing, unfortunately, redundancy consultation processes if their business is one where they are unlikely to see any change beyond October. And certainly that is what we're advising a lot on at the moment. So I also just wanted to touch briefly on the changes to the Ssp regime, as well as the very recent changes that were announced kind of last Thursday and Friday in respect of notice pay and statutory redundancy pay and how that's calculated. So firstly, Ssp. Employers with fewer than 250 employees will be able to recover the cost of Ssp for any corona related absences. The size of the employer will be determined as at the 28th of February 2020. And essentially businesses will be able to reclaim up to 2 weeks pay for any eligible employees who have been absent because of issues related to the coronavirus. So it's worth remembering that if you are a smaller business. The amended Ssp regulations also permit Ssp to be paid from day one of an absence that's related to coronavirus, rather than the normal day 4 that we see for normal absences. And that applies retrospectively for any absence on or after the 13th of March 2020. And then finally, it wasn't covered in the invite because it kind of came out of the blue last week, but the government announced last Thursday that they were going to legislate to ensure that any employer that makes a furloughed employee redundant would need to calculate their statutory redundancy pay and their statutory notice pay, amongst other payments, with reference to the employee's normal pay as opposed to their reduced furlough pay. Now, I know a lot of businesses were doing that anyway, but it has now been legislated and that has come in effect from the 31st of July. So if you are looking at making any redundancies, then it's just making sure that you are using the correct kind of calculation of their normal pay rather than the reduced furlough pay. So that briefly covered off the areas that I wanted to run through, and I think I can see we've had a number of questions. So do you want to kick that off, Cristina?
Yes, we have, which is good to see. Thank you, three of you. That was very succinct but comprehensive overview of those areas. Emma Brooksbank, I think this one is probably for you. If the government's not planning to provide a lower skilled route beyond the seasonal agricultural worker scheme, how does it affect the food and agriculture sector to meet its workforce needs?
Yeah, so I mean, this is the question I think that lots of businesses in the sector are grappling with. The Home Office and DEFRA, when they published the seasonal agricultural worker scheme policy, and actually during the precursor, so we've had previous source seasonal agricultural worker schemes going right back to 1945. Have always said that they don't want the scheme to meet the workforce need in full, that they've always intended that it's almost like an emergency mechanism, that's the intention. But of course, since the 70s and since we've had free movement, it's been acceptable to a certain extent for that scheme to be that kind of emergency valve to provide additional numbers, because we've had unlimited free movement from Europe. But I don't think that Home Office and DEFRA have really got to grips with the impact of the end of free movement on the sector. Now, what would they say? I think the question was, how do they expect the sector to meet their workforce needs if there's no low-skilled route? What they say is they expect the sector to look to agri-tech, and they expect the sector to look to the domestic population, so the UK-based population, to meet workforce demands. Now, I'm sure businesses working in this sector will know or will agree that there are challenges with both. Certainly there are always an ongoing developments in agri-tech, but is it really realistic to anticipate that agri-tech can provide a solution, a sufficiently robust solution in the short time frame that we have? I don't know many firms within the sector that think that that's achievable, either for investment reasons or because the tech simply doesn't exist at the moment. Or it's just not a viable and adequate solution to actually what they need, which is 80,000 workers. And then UK domestic population, it makes sense, doesn't it? If we're seeing much higher levels of unemployment, the idea really that if you have one settled worker, so UK-based worker unemployed and one vacancy, then the two should just match beautifully and solution is there. But of course, again, that's just not realistic. And in some ways, the COVID crisis enabled the sector to trial that, because we had the Feed the Nation policy. It was heavily promoted, the kind of Pick for Britain policy, and while there was best intentions, and while people were furloughed, they were keen to help. The reality was that it wasn't viable for them for geographical reasons. It wasn't viable because they had caring responsibilities. It wasn't viable because they were having to travel too far, or the work just wasn't of the nature of the type of work that they would want to be doing. So this idea that we have a pool of domestic workers who are just ready to meet that workforce demand, I just don't think is realistic. So, you know, it's a tricky one. I hope that pretty quickly, I'm not holding out much hope for this, but I hope that pretty quickly the Home Office will realise that actually agritech and a UK workforce are not available in the short term to meet the great demand that the sector has.
Okay, thank you very much. Dan, there's a question for you. There's a couple that I'm going to combine. So one is, how is the government's workplace guidance being enforced in the sector, and what advice would you give to employers when bringing people back to work in the office, balancing the HSE and the government guidance? Okay.
In relation to the first question, certainly the government guidance is, the regulators are monitoring compliance with the government guidance. So we're talking about the Health and Safety Executive and local authorities. They're carrying out the inspections. They are checking whether the sector is complying with government guidance. And they, of course, have enforcement powers if they feel that they need to use them, which include the service of improvement notices or prohibition notices, which obviously have the potential to severely restrict, or in more extreme cases, prevent businesses from operating altogether. And of course, in more serious cases, the regulators also have the power to bring criminal prosecutions. In terms of how the picture's looking at the minute, the regulators, yes, they're carrying out the inspections, but they're not really flexing the muscles. They're not really using their enforcement powers. Yes, they're giving words of advice, but in terms of actual service of notices, I'm aware of 12 that have been served nationally across all sectors, which is quite remarkable given the circumstances. And that suggests one of two things. Either businesses are clearly complying with government guidance, or for whatever reason, the regulators are being hesitant in serving notices. I obviously don't know the answer. I suspect the answer is probably somewhere in the middle, but that's how it's being monitored and enforced at the minute. And I do expect going forward that the use of enforcement powers will increase. So that deals with the first question. In terms of giving advice to employers when bringing people back to work, as I mentioned previously, the risk assessment is absolutely crucial, and it is very important that employees are involved in the risk assessment process. They need to be consulted during that process, and the results of that risk assessment need to be shared with those employees as well. So that's the first thing that any regulator is going to check, and that's the first thing that employers need to do and need to be able to evidence if asked by the regulator. Obviously, the government guidance, there are similar themes when you look across all 14 publications. Social distancing is an obvious one. Enhanced cleaning regimes is another. Working within specific and small bubbles, as they refer to it, is obviously something else which employers need to look at as well. I do think that employers also need to remind their employees about their obligations under health and safety law. They need to check before they return to the workplace. Well, do you have any symptoms of COVID-19? And as an employer, I think that would be a sensible measure to take, to ask the employer to essentially complete a questionnaire to confirm in writing that they're not suffering from any symptoms, and to have that on record so that if there is an outbreak, the employer can demonstrate to the regulator that they've taken reasonable steps to protect their workforce. I don't think, and the government guidance certainly doesn't mention this, there's no obligation on employers to carry out any testing as such. I mean, that may come in due course, but not at the minute. But I do think that they need to be asking questions of their employees before any return to the workplace, certainly.
Okay, thanks, Dan. I think this question's for you, Emma Batten, and it's quite pertinent given the more and more countries seem to be being added to the list of places we can't go to. Can we put a blanket ban on foreign travel to prevent self-quarantine upon return?
Yeah, that's a really good question, actually, and has certainly been something that has come up with our clients. I think the first thing to note is that COVID hasn't changed the law regarding kind of personal travel plans of an employee. They still have the right to take holiday and to use their leisure time as they wish, essentially. And I think implementing a travel ban across the board could potentially have a risk of being indirectly discriminatory, perhaps for those employees who are foreign nationals who would travel abroad to go back to see family, for example. So I think a blanket ban of foreign travel is probably would be a risk. And obviously there are some safe countries now that have air bridges with the UK, which don't require a period of quarantine. But as we all know from the news and the recent changes to those lists of safe countries, like what we've seen with Spain, and then just last night, Belgium, Andorra and Bahamas have been removed from the safe list. These things change very quickly, and an employee may have gone away not knowing that they would be required to quarantine upon their return. So I think the key really is about having kind of open and honest discussions about travel plans with the employees. And I can see one of the questions is whether it's, another question is whether it's reasonable to ask colleagues about their travel plans. And I think that is perfectly acceptable. I think particularly in the climate at the moment, understanding where employees are intending to go so that there is a record of that, and obviously obligations on the employer to make sure that they are doing what is right if they are aware of where employees have been and the fact that they need to quarantine on their return. I think that is acceptable. I suppose the only caveat I would add to that is just, if we're going to be asking employees about their travel plans, making sure that we're asking everybody. So again, it not being directed at foreign nationals, for example, everybody, regardless of their nationality, be asked what they are intending to do with periods of annual leave. Now, in terms of what we can, if we're not able to put a kind of blanket travel ban, which, like I say, I think that would probably be too extreme. What we could do, if businesses are looking to prevent employees going on annual leave, the working time regulations do permit an employer to give notice not to take a period of annual leave. So to cancel that period of annual leave, an employer would have to give the same amount of notice equal to the period of annual leave. So for example, if an employee was taking 7 days, they would need to give 7 days notice to cancel that. But again, I think we just need to be a little bit cautious. If that period of annual leave had been pre-approved and perhaps holiday has already been booked, then businesses may want to consider, if they do feel very strongly about not allowing an employee to travel abroad, whether they are going to put any provisions in place to cover the cost, which may not be covered by insurance, or if the employee is unable to rebook it for next year, for example. So I think the key really is about ensuring that there is communication with the staff, that they understand the reason why these questions are being asked. And perhaps that is something that is something that's relevant for the risk assessment, for example, so that there is clarity in terms of travel plans and what is expected of employees upon their return from foreign holiday.
Okay, thanks, Emma. So back to you, I think, Emma. Somebody's saying that they've got an existing and loyal European workforce. Is there anything they can do now to retain them for next year? Have you got for next season? Have you got any views or advice on that?
Yeah. So if we have existing European workers who are with us now, well, let's separate this into two. Let's separate it into our sort of long-term workers and then our seasonal workers. So say we've got our existing long-term workers, they should already have applied for leave to remain on the European Union settlement scheme. They probably have, over 3 million people have, but I still come across people every week who I would have anticipated would have known about the scheme and don't. So, you know, if we do have an existing workforce, they're here, they're staying in the long term, then we really need to ramp up communication to them to make sure that everyone who needs to apply has applied onto that scheme. Deadline's 31st of December with a grace period through till the 30th of June. But without getting into the technicalities, the grace period does create a real grey area legally in terms of their status. So my advice is the communication which goes out should be saying, ideally, use the 31st of December as your deadline, knowing that you've got the buffer, but ideally don't use the buffer. Now, the more interesting question, I think, comes up for seasonal workers. So it is quite common for cohorts of workers to return to the same farms or the same areas, harvest after harvest after harvest. So it's quite common, even though people are coming for a short time, so a matter of months, those people might have been coming for years and years, and they'll know the procedures. There's a loyalty there. The company knows that the farm knows those people can be relied upon, and there is an incentive on both sides for that arrangement to be able to continue. Now, of course, it's possible to use the seasonal agriculture workers scheme, but if they were wanting to not get embroiled in the immigration scheme, it would be possible for those people to use the settlement scheme now. So bearing in mind that the settlement scheme is very straightforward, it's free, it gives them lots and lots of flexibility. So if they were here now, say in this season, they could apply because they're resident now onto the settlement scheme. They would be given 5 years, what's called limited leave to remain, and they could still leave, return to family. And as long as they were spending a period of 6 months in every year in the UK, they wouldn't lose that limited leave to remain. So it could be a really good option for them because they've got this, you know, nice, flexible, long-term period of leave. And as I say, if they were absent for less than 6 months in every year, they wouldn't lose it, and they would qualify for what's called indefinite leave to remain at the end of that period. So those people might not naturally think of looking to the European settlement scheme because they might think, well, actually, my home is overseas, I'm just coming over to work for a period of time. But if they can structure their working arrangement, and if the farms that they're going to work on can structure their working arrangement so that essentially it's 6 months in, 6 months out, then the settlement scheme does provide a really good long-term solution and should be thought about, I think, in those terms. If not, if they're saying, well, no, actually, I only come for 2 or 3 months and family commitments back home or work commitments or whatever it might be, mean I'm only going to be coming for 2 or 3 months, then they'll need to be bracing themselves for the full-blown immigration system, which will be the seasonal worker visa.
Okay, thanks, Emma. Sticking on a seasonal worker question we've got here, which I think is probably for you, Emma, is what should we do if a seasonal worker has been advised to self-isolate via the track and trace scheme?
Yeah, that's a good question. I'm sure most of you are aware of the track and trace system. It seems like it's marred with a lot of problems at the moment, which seems to be all people are talking about. But essentially, it is a system whereby if somebody has tested positive for COVID-19, they will then be contacted by Public Health England, and they will try and identify those individuals who they've been in close contact with and who may have been exposed with COVID-19. Those individuals will then be required to isolate for a period of 14 days, whether they are showing symptoms or not. And although it is currently voluntary, and there is some question marks as to how it is going to be enforced, there's no legislation enforcing this system, although the government haven't ruled it out. So again, if we are seeing outbreaks and people kind of flouting the track and trace system, then that may be something we see in the future. But I think businesses, as we do get to grips with this more and more, I think businesses do need to be alive to the fact that there may be increased absences at short notice if employees are notified that they've been into close contact with somebody who has had COVID. And I think the key really is making sure from your business's perspective that social distancing is being adhered to, because if it has been correctly adhered to and an employee receives an alert that they've been in close contact with somebody who's been diagnosed with COVID, then it will lessen that ripple effect in terms of other employees having to go off work. So again, I think it's within the business's interest to make sure that employees understand their obligations in respect of that. But regarding the specific question about what if they are notified that they need to self-isolate, well, obviously the first point is they will need to be sent home immediately and required to self-isolate from home. Now, obviously seasonal workers won't be undertaking the type of work that can be carried out from home. But for those employees that perhaps are office workers, obviously as long as they're not ill, then there is no issue for them to be required to work from home for that period of self-isolation. And again, I think it is really just about ensuring that employees understand their obligations and the fact that they are unable to return to work for that period. And in terms of kind of practical steps that we've been talking to clients about how they can ensure that they are meeting their obligations here, well, firstly, it's about ensuring that employees understand their obligations, so know they need to contact their employer as soon as they become aware that they've been contacted by Public Health England, and ensuring that they understand that they won't be expected to finish their shift, essentially that they need to self-isolate straight away. Employers should be asking for a copy of the notification received. So practically speaking, that will assist in terms of any rebate claim for SSP, because like I said earlier, if you're a smaller business, you'll be able to claim that back. And just making sure that we've got up-to-date contact details for everybody. I mean, I'm sure HR do this anyway, but in today's current climate, it is more important than ever to ensure that we have people's contact details. So if an employee who has been diagnosed with COVID has been in close contact with another individual, we need to be able to notify them without them coming into work and risking further infection. And ultimately ensuring that employees understand that if they breach this, then it is potentially a disciplinary misconduct issue, because it could have very serious implications for the company. So employees just need to be understanding what their obligations are in respect of that.
Can I just add a point to that from health and safety perspective very quickly? I think the other thing to bear in mind here is, yes, employers have a duty under health and safety law to safeguard their employees and their workforce, but employees themselves also have a duty under health and safety law. So if you have, and I think employers might want to think about explaining that to their workforce and saying to them, well, look, you need to be honest with us about whether you have any symptoms, because if you don't declare it and you come into the workforce and there's a cluster of infections, then the employer will be looked at, but the employee should be looked at as well from a health and safety perspective. So that's something that employers may want to remind employees when talking about risk of transmission. They have a duty, but as much as the employer does.
Okay.
Yeah, a lot of our clients have, and I'm sure a lot of businesses have done the same, but put together some kind of FAQ document that is constantly being updated, because obviously, as we've seen, the government guidance is changing relatively regularly. So just making sure that there is that central function for employees to be able to access that answers kind of frequently asked questions, and that it is all in one place for individuals to refer to if they need it.
Okay, thank you. Question I've got here: should the food sector expect any changes to government advice on how to remain COVID secure? Is that one for you, Dan?
Yes. The short answer is yes. I say that because the guidance has been changing throughout the course of this pandemic and will continue to change as we learn more about the virus and how it's transmitted. In terms of how it's going to change, personally, I think potentially the guidance will change when we look at PPE and face coverings. When we talk about personal protective equipment, the guidance currently says, in essence, unless you needed it before the pandemic, then it's unlikely to be deemed necessary as a safeguard during the pandemic, unless you are one of the close contact services. So, for instance, hairdressers, beauticians, etc. And in those circumstances, the recommendation is to wear a visor. Where face coverings are concerned, there's been even more of a change from the government perspective. At the start of the pandemic, the government's advice was, well, the face coverings have no benefit. That's changed. We all know it's now law to wear face coverings on public transport. It's now law to wear them in supermarkets and shops. And as of tomorrow, it will be law to wear face coverings in cinemas, museums, and places of worship as well. So, yes, I think it's likely to change in that regard. In relation to the workplace, it's not changed as much, but what the guidance currently says, or what it acknowledges rather, is that face coverings may be marginally beneficial. It doesn't say that employers should mandate them, but what it does say is, yes, they may be beneficial, and if employees want to wear face coverings, then they should be allowed to do so.
Okay, thanks, Dan. It's coming up to 20 past, so I think we've got time we can squeeze one more question in. What can companies do about employees who don't want to return to work? Emma, one for you?
Yeah, again, this is something that we are seeing a lot of. I think there obviously has been a prolonged period where individuals have either been furloughed or they've been permitted to work from home since March. And so coming back to normality is something that I think is causing a lot of anxiety amongst employees. So it is certainly something that we are advising on more and more. And again, I think the key really is to understand the reasons for not wanting to return to work, and trying to offer some reassurance wherever possible. So, for example, a lot of employees may have difficulty returning work because of childcare issues. And we were talking earlier, I have complete sympathy with that because I myself am struggling with childcare during the summer holidays. So in that respect, I think perhaps there needs to be a discussion around perhaps parental leave being taken, or there being a little bit more flexibility in terms of allowing individuals to remain working from home until perhaps September, when, fingers crossed, the kids go back to school. If it's not related to childcare and it's more about kind of general anxiety about not wanting to come back to the office, or perhaps it's regarding employees that have previously been in the extremely vulnerable category who had previously been shielding. Now, in respect of those individuals, obviously we've seen a bit of a shift in terms of the government guidance, and shielding has essentially been paused from the beginning of August. And providing employees are unable to work from home, then they are being encouraged to return to the workplace, providing it is COVID secure. And I think that's the key, really, is to ensure that you are having the discussions with your staff about what measures have been put in place. And like Dan was saying earlier, obviously there is that obligation to have a risk assessment in place, and to have those discussions with staff, to be answering any questions or any concerns that they have about specific areas that perhaps is causing them concern. And just really offering as much reassurance as possible, and getting to the bottom of the reason why they are feeling anxious about returning to work. Now, for those employees that are in the extremely clinically vulnerable category, we do have to be alive to the fact that they are possibly going to be considered as having a disability under the Equality Act, and therefore there may be an obligation to make further reasonable adjustments in respect of their position. And certainly I actually went on the government guidance this morning and filled in a questionnaire to see whether I should be returning to work, and if I was in the extremely vulnerable category group, then I'm encouraged to return to work if I'm not able to work from home, but adjustments such as perhaps a temporary adjustment to role, or changing hours or shift patterns, for example, if that's going to reduce the contact that individuals have, then it's about kind of considering those options. And I think I would just highlight the fact that we need to be slightly more mindful about those employees that could have disabilities because of that additional obligation to consider reasonable adjustments. And obviously we're at a stage where we don't really know what a tribunal is going to say in terms of how hard businesses come down in terms of requiring staff to return to work. I think certainly that's something that we are going to see claims. I mean, we've had a number of claims filed already from some of our clients dealing with this issue, but obviously we are months and months off a tribunal considering the actual intricacies of the decisions made. So as woolly as it sounds, I think we just need to be acting reasonably, offering reassurance wherever we can. And if there is a potential alternative, particularly for those employees that are potentially going to be considered as having a disability, then looking at whether we can do that in the short term.
Okay, thank you. I think we've probably got time just to squeeze another one in there if we're quick. Emma, is it too late to hope for a reversal of policy and for provision to be made for a lower skilled and or temporary visa route?
It's never too late, is the answer. You know, for this sector and for so many other sectors, a proper, well thought through, fit for purpose, lower skilled visa route is essential. It was in the original plans for the 2021 immigration system and was then edited out. Essentially, it was something that was consulted upon heavily, and all sorts of different schemes were considered by the Home Office, and unfortunately for many sectors none of those schemes were put in place, and so all we have is the seasonal worker scheme. Now, you know, we could have a change in direction in terms of government policy. That's a possibility. In the future, of course, we'll have a different government at some point. So it's not something to let go of. But my view is that even in this short space of time between now and the introduction of the new immigration system, this sector and the bodies that support it and the other sectors that will be heavily affected by a lack of an adequate lower skilled visa routes, such as manufacturing, logistics, care, etc., still need to be shouting loudly and lobbying government about the impact that the lack of available on-demand workforce is going to have on their ability to operate. So it isn't there now, but yeah, my message is no, it's not too late. Let's keep shouting and try to push for those changes to be introduced before the end of free movement and before the system's introduced in January.
Okay, thank you. That's perfect timing. Okay, right. Before I wrap up, I just want to remind everyone that we've got an HR forum on the 15th of October, which we're hoping is actually going to be a live event, all things being equal, and I'll keep you all updated. But if anybody's got any ideas or pressing concerns that they want discussed at this meeting, please do let me know. The other thing that I'm starting to work on now is our annual salary survey. So if anybody's got any questions they'd like included in that, please again let me know. So thank you all for coming, and many thanks to Emma, Dan and Emma. I hope you've all found this really interesting, and you've gone away with some answers to your questions. It was good to see we had quite a few questions coming in. Like I said earlier, the session is recorded. If you want a recording, please let me know and I will send you the link. And if you ask a question it wasn't answered, don't worry, because it will be directly answered. Okay, so thank you all, everyone, for coming. Thank you. Bye-bye.
Thank you.
Bye. Bye. Bye.